Hello colleagues, how are you? I want to prepare a short presentation of European data protection law. You will find my PowerPoint slides on the internet on my homepage. I will mention where you can find it. I apologize for my bad English pronunciation. I speak like a former Bavarian minister who had a very, very nasty language when he speaks in English. But I'm German and I cannot speak it in another way. So, let's start with the first session. What I have prepared is 4 units. The first unit is a course in the course program is a unit on fundamental of data protection in Germany and the EU. Second unit is a unit on EU secondary data protection law. That means the General Data Protection Regulation. I've planned a third unit for data export and data protection supervision because that's very important in Europe. And the fourth unit is one on national and sector-specific data protection law. That are all different units and different videos which I have planned. Let us start with an outline. I want to explain to you the history of data protection in Germany, constitutional principles in Germany, and primary European law. So when you don't understand anything, do not hesitate to contact me to answer. I will answer all questions which you send to me. So, the history of data protection law in Germany. To be honest, it all started with the Nationalsozialist regime, the regime of Adolf Hitler in Germany. People became afraid of the state and said the state is so powerful and he tends to control every aspect of human life, and we don't want to be controlled and supervised in so many areas like in the 40s and 30s of German history. The second element of the subject was a very remarkable article which was published by Hoeren and Brandeis in 1900 in the Harvard Law Review with the famous title of The Right to be Let Alone. That was a feeling in the United States. The state should not interfere with any normal way of expressing yourself. It's your life and the state should avoid any control. That leads to with 2 sources of data protection law. That means, as I said, Hoeren and Brandeis, and the fear of the German population after the Second World War led to very early acts. It started, to be honest, in Sweden, which had the first statute on data protection law in Europe, and then the state of Hessen made the world's first data protection law in 1970, and 7 years later we had the first Federal Data Protection Act in 1977. So we had then the first federal data protection law for every state in Germany. And then happened a strange thing, the Constitutional Court. We are very, very honored to say we have one of the most powerful constitutional courts in the world. And in the beginning there was no explicit fundamental right foreseen in the Constitution, no mentioning of data protection, privacy as fundamental right. But then the Federal Constitutional Court started to think about privacy and data protection in the famous Census ruling, and that started the story of a right to informed self-determination. A right to self-determination means das Recht auf Selbstbestimmung. A citizen should have a right to decide if and how he will give his data away. That was the first constitutional fundamental of data protection. And then in 1983 we had a very nice decision, a landmark decision, the famous Census ruling of 1983. There the court said free development of personality presupposes, under the modern conditions of data protection, the protection of the individual against unlimited collection, storage, use and disclosure of his or her personal data. This is a fundamental right under Article 2 and Article 1 of the German Constitution. The right guarantees the power of the individual to determine for himself the disclosure and use of his personal data. The court even said more. He said every person, if it's a state or a private company, has to clearly define in advance what is the purpose of data collection. So you have to have very clear definitions for which purpose you collect data. And data protection processing must be limited in content and time to the absolutely necessary extent. The court then distinguishes between secrecy interests of the person concerned and sensitive data versus not so sensitive data. Every data is protected under data protection, but you need specific protection for highly personal content, so like for instance sexuality. That should be a higher level of protection. Article 2 and 1 are foreseen for this right to self-determination. Apart from that, we have Article 10 of our Constitution, which protects the secrecy of telecommunication. So private communication using telecommunication traffic is protected under a specific fundamental right. So, on the basis of informational self-determination, we have the two fundamental rights. On the one hand, the general principle of self-determination, and we have a right of protection of secrecy of telecommunication. How do you delimit between these rights? Secrecy of telecommunication is only there until the completion of transmission process. So when the transmission process is ended, so that the recipient has control over information, this is general principle of self-determination. But on the way of telecommunication, if the recipient has not yet control, that is secrecy of telecommunication. And then the court, even if later decision, invented a third right, the right of protection for the integrity of IT systems. That is a fundamental right to protect the entire IT system. So we not only have the German Constitution, but we have primary European law. That is especially true for the Charter of Fundamental Rights, and that has a provision in Article 8 on the protection of personal data. Personal data, that means any information relating to an identified or identifiable natural person is protected under European primary law. And so ID card numbers, telephone numbers, account numbers, IP addresses are all part of data protection in the European sense. When you want to justify interventions, that's possible under the European Charter, but you have to comply with Article 52. That means you have to specify the purpose of the data processing. So, and the article we don't only have the Charter of Fundamental Rights, but we have as well European Convention on Human Rights. This is an international treaty which even protects more data. That is a principle in Article 8, a right to respect for private and family life, against the intervention by the state. Justification can be made either by statute or by a legitimate aim, but you have to stick to the rules of proportionality. That's very important. So you can ask yourself, what is the relation between the European Charter of Fundamental Rights and the European Convention on Human Rights? Both rights are closely related, so it cannot be argued that the Charter of Fundamental Rights has a lower level of protection. It must be higher. So the European Convention on Human Rights is not binding for constitutional courts, but the constitutional courts have to interpret national constitutional laws in accordance with the European Convention on Human Rights. So it's very important to know these three sources. That means you have to understand that we have a national constitution, for instance in Germany, protecting personal data. In Germany we have three fundamental rights in national constitution. That is the right to self-determination, the right to secrecy in telecommunication, and the right to integrity in IT systems. That is all national. Apart from that, we have the European Charter of Fundamental Rights, which is binding for all European states, protecting as well privacy. And then we have the European Convention of Human Rights, which protects as well the freedom to private life. All these different regulations are based on the assumption we protect the data of identifiable natural persons. We don't protect the data of legal persons. That is a part, there's a principle which is linked to secrecy regulations. We only protect in data protection the data of natural persons, and the natural persons are still living. If you're dead, you don't need data protection. And you should be identified or identifiable. So if you can track down certain data to a natural person, that is all data protection. And the general principle is every data belonging to an attribute to a natural person is protected and cannot be used. If you have doubts, the processing of personal data are prohibited. This is a strong, very strong principle in Europe. As an exception, you can, as a regulator, as a corporation, say, I want to use the data, but then you have very clear concept and justification for the purpose of using the data. Either you have a statute allowing you to use the data, for instance, as a state, or you have a legitimate interest which allows you to use the data, and in any case you have to stick to the rules of proportionality. That means you can only use the data for whatever purpose as long as the purpose is still valid. You have to stop using the data in the moment where you don't need this data anymore. And the rest, how it works, will be explained in one of the next units. So thank you very much. I hope that is good for you to understand, and you will follow me for the next units. Bye bye.